Morning, sir. You're John Van Wright?
Yes, ma'am.
And will your client waive the formal reading of the motion and the indictment?
Yes, Judge.
Mr. Van Wright, in cause number 24, DCCR 2485, you're charged with, the state has elected to proceed on count one only. It alleges you committed the third-degree felony offense of injury to an elderly individual from November 14th of 2024, and how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have, in that case, some documents here on the tablet that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them sorry, I just went blank, Mr. Mitchell. I was going to say Mr. Brennan. It's like I knew that wasn't right. With Mr. Mitchell. And do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you made with the district attorney, that you're waiving or giving up any right to appeal?
Yes.
And so y'all have marked off a fine also. Is he paying a fine and 2 years in prison?
On the new case, yes, Judge.
It should just be a $500 fine on the new case itself, not the MTR.
Okay, so when's that going to get paid?
Can you pay that before the 15th?
I mean, if he's going to prison, what's the...
We always do the fine and prison time. But
Okay, that's
we can
fine.
scratch off.
So, no, I just, whatever.
I'm good with scratching it off, Judge. It's fine.
Well, y'all agreed to it, so you understand that the agreement is for a 2-year term in prison, a $500 fine. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
And I thought you had said 4.
Further negotiations, Judge. I did clear it with the victim before. He's
Okay,
upstairs, but he was okay
he was
with, yes,
with the 2?
with 2.
Okay, thank you. All right, state tenders number 1.
No objection, Judge.
Is there any, it's admitted, is there any evidence that Mr. Van Wright is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing to Monday, December 15th at 9 o'clock. You'll need to report back here. I'll go through sentencing on that date. It's very important. Well, let's go through the other case and then we'll talk about consequences of not getting here. Let me send this.
Oh, I'll be here.
And then, so in cause number 15-23582, we were previously here and Mr. Van Wright had entered a plea of not true to allegation number 1. Is it my understanding that he wants to change his plea to that allegation?
Yes, Judge.
Let me get that pulled up again. So on probation for injury to a disabled individual, and count 1 alleges that you committed the offense of injury to an elderly individual, the case that we just went through, and is that true or not true? Are you entering your plea of true freely and voluntarily?
Yes, ma'am.
And because that count is actually true.
Yes, ma'am.
I also have some documents here on the tablet in that case that have your signature on them that the state's marked as exhibit number 1. Did you also sign these with Mr. Mitchell?
Yes, ma'am.
And do you fully understand them? And again, you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal. State tenders number 1 in that case.
No objection, Judge.
It's admitted. All right, so I'm going to find that you entered your plea of true to count 1 freely and voluntarily. Find that count true. Find sufficient evidence to revoke your probation, but I'm going to, again, reset your case for sentencing till Monday the 15th at 9 a.m. It is, again, very important that you're here and on time. If for any reason you're not, then you run the risk of me not accepting these plea agreements and things could be much worse. Do you understand?
Yes, ma'am.
All right, then obviously I don't need any kind of pre-sentence report or update as well, and we will see you back on the 15th.
Thank
Okay,
you, Judge.
thank you.
Ma'am, do I need to still see my probation officer?
Between now, no.
No.
Thank you, Judge.
Thank you.
Appreciate it.
Thank you.
I mean, I don't guess there's any reason for that for 2 weeks if you're getting revoked. James Boswell. Good morning, sir. You're James Boswell. And this is cause numbers 25 DCCR 0992 and 0993. Mr. Boswell was previously in court, entered pleas of guilty in each of those cases, and I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Any additions or corrections?
None from the defense, Your Honor.
All right, Mr. Boswell, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. In cause number 25, DCCR 0992, find sufficient evidence to find you guilty. However, I'm going to follow the agreement and defer all proceedings and place you on probation for 6 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. In cause number 25, DCCR 0993, I'm also going to find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 6 years and order you pay a $500 fine. In addition to those requirements, I am also going to order that you are not allowed to possess any firearm at all. If you still have firearms in your home, then they need to be removed within 24 hours. They took them all? Okay. This whole situation and how you're treating people that live around you, the racial issues that are going on is ridiculous. And so you need to do whatever. If you go to work, come home. But all this interaction in the way that you have interacted with the people that live around you and what you did to these young kids probably scared them to death. And you're here, lucky you're not here for murder. You're lucky that I'm going along with this agreement because I don't really like it. I don't like what you did. I don't like how you treated those people, and I don't like what you did to those children. And it's going to stop, or you're going to end up in prison. There will be no, I made a little mistake and let me stay on probation, or let me go to some middle of the ground, ISF or something. If you make a mistake on this probation, you will be going to prison. And in these cases, you can go between 2 years and up to 20 years. Do you understand? Part of this is you'll be on the high-medium caseload, and you're going to go through an assessment for any type of mental health treatment that you need. And if they say you need something, then you're ordered to do whatever it is that assessment says. That's in order to help you so that you can make better decisions and take care of this probation while you're out on the streets instead of going to prison. Does that make sense? All right, I'm going to hand you in each of your cases the trial court certifications that shows that these were agreements that I followed and you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up when she's ready to go over all of your paperwork. Go have a seat. Good morning, sir. Are you Sean Dage? And Mr. Dage, this is your initial appearance in cause number 24, DCCR 2353. You're charged with the state jail felony offense of evading arrest or detention with previous convictions, and that's from October 20th of 2024. Your indictment alleges a couple of other prior state jail felonies back from 2011, it looks like. So since you've made bond in your case, have you had an opportunity to try to hire a lawyer? So when you were in jail, we automatically give you a court-appointed lawyer, but now that you've bonded out, I'm going to expect you to try to hire your own lawyer. So what I'll do is reset your case about 30 days or so to give you some time to try to hire someone. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand? All right, if you step in front of the clerk right here, she'll give you your reset notice. Good morning. Are you a Caiston Howard? Aston Hayward. Sorry, I said that all wrong. And Mr. Hayward, this is your initial appearance in cause number 25, DCCR 1346. You're charged with the state jail felony offense of burglary of a building from August 29th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? So what I'm going to do, how old are you?
16.
Are you still in school?
Yes, ma'am.
Where do you go to school?
Wizard.
Okay, and you're currently attending school right now?
Yes, ma'am.
All right. So if you are unable to hire an attorney because you're still in school, you qualify for a court-appointed lawyer. Do you want me to give you a court-appointed lawyer, or is your family going to help you hire someone?
Is my question.
Okay. All right. If you will, you ready? Step in front of the clerk. She'll give you that information. Good morning. Are you Carisha Mays? And Ms. Mays, this is your initial appearance in cause number 25, DCCR 1464. You're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from September 26th of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer? I'm sorry, answer out loud. So, are you working? Why not? Okay, so here's what I'm going to do. I'm going to reset your case for about 30 days to give you some time to get a job. So you need to get a job and bring me proof that you have a job, or you need to bring me proof that you have applied to at least 5 jobs a week when you come back, okay? In the meantime, also, I expect you to try to be at least talking to attorneys so that when you get a job, you will be able to at least try to hire one. So you also need to talk to at least 3 lawyers between now and then, see what they cost, talk to more if you need to. They all charge different amounts, have different plans to pay and all of that. Bring me at least the 3 names, if not more, and the information about your job, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand? All right, step in front of the clerk. Good morning, are you Erin Riley? And Ms. Riley, this is your initial appearance in cause number 25, DCCR 1194. You're charged with the third-degree felony offense of assault on hospital personnel from July 23rd of 2025. Since you've made bond in your case, have you had an opportunity to try to